I'm Ben Meiselas from the MeidasTouch Network. Special Counsel Jack Smith filed 4 separate oppositions to the various motions Donald Trump filed in the Washington, D.C. federal criminal prosecution set for trial March 4th, 2024 before Judge Tanya Chutkan. Of course, the Washington, D.C. case relates to Donald Trump's attempt to overthrow the results of the 2020 election. All of Donald Trump's motions have the same design. You guessed it. Delay, delay, delay. And Special Counsel Jack Smith has been calling them out with each of the oppositions that Jack Smith filed on Monday. 4 oppositions Jack Smith filed on Monday, including this one. The government's opposition to defendant Donald Trump's motion to stay the case pending resolution of motion to dismiss based on presidential immunity. Let's unpack that. For those longtime MeidasTouch watchers, you know we get into the weeds of all of these filings because they all have significant impact. So Donald Trump filed a motion to dismiss the Washington, D.C. federal criminal indictment on multiple grounds, from purported vindictive prosecution, statutory constitutional grounds, double jeopardy grounds, and presidential immunity grounds. And specifically here, Donald Trump argued that his conduct as it relates to presidential immunity under Article 2 of the United States Constitution, Donald Trump claims, is that his conduct relating to and on January 6th falls within the outer perimeter or parameters of presidential authority. That's absolutely absurd to say that efforts to overthrow the Constitution fall within the outer perimeter of constitutional power. So this is a frivolous motion, folks, that Judge Tanya Chutkan is going to reject. But one of the ways Donald Trump is trying to weaponize the presidential immunity motion in order to try to delay the March 4th, 2024 trial. That's Donald Trump's plan. Delay the March 2024 trial. Is he saying because case law says that presidential immunity is a threshold issue, then what Donald Trump filed, and you know we covered it here on the MeidasTouch Network, was a subsequent motion to stay the entire case and the March 4th, 2024 trial date, all of the proceedings until Judge Chutkan rules on the presidential immunity motion that Donald Trump filed, claiming that since presidential immunity is such a threshold issue and immunities need to be resolved at the outset, that the case should not proceed. And I said, what Donald Trump is really trying to do there, and why he's also filing these multiple motions versus one omnibus motion, because what you would normally see in mostly every other case is not 4 or 5 separate motions to dismiss. You'd see one, and there'd be different arguments: vindictive prosecution, presidential immunity, double jeopardy, whatever your arguments are, all frivolous, all will be rejected, but you'd file them as one motion. So what is Donald Trump's strategy here? File 4 or 5 of them and then try to appeal them all to the D.C. Circuit Court of Appeals. When Judge Tanya Chutkan denies the motions to dismiss, then ask the D.C. Circuit Court of Appeals for a stay, and hopefully you draw a panel. These are 3 judge circuit panels, and maybe you get some judges that are sympathetic to Donald Trump on a 3-judge circuit panel, and they kick the March 4th, 2024 trial date. So that's Donald Trump's strategy here. He knows Judge Chutkan's going to reject this motion to stay, and Judge Chutkan's going to reject Donald Trump's motion for presidential immunity. But Trump's audience and his strategy is, let's wait as far as possible to the very last day and deadlines when these things could be filed. Then let's bring the motion to dismiss and then a motion to stay. And then let's try to disrupt that March 2024 trial date. So here, Special Counsel Jack Smith is filing an opposition to Donald Trump's motion to stay pending resolution of the motion to dismiss based on presidential immunity. So now we've unpacked it together, right? So Trump filed presidential immunity motion to dismiss, entirely frivolous. Then Trump said, motion to stay, delay the March date because I filed that presidential immunity motion to dismiss. And here Jack Smith is swooping in and saying government's opposition to all of that. And Judge Donald Trump has revealed his strategy. We know he's trying to knock off that March 4th, 2024 trial date. So what we would request, Your Honor, is that you, in your prioritization of your orders, rule on the ones that could be subject to this interlocutory review, this immediate appeal to the D.C. Circuit Court of Appeals, so that Donald Trump can just be forced to have to exhaust that effort right away, which Trump is going to do. He's going to ask the D.C. Circuit Court of Appeals for stays and administrative stays, just like he did with the gag order. The gag order stay and the gag order proceedings, those don't derail the trial date. These other ones Trump's going to use to try to derail the trial date. What I think also that Judge Tanya Chutkan's probably thinking on her own as well is, and even though Jack Smith doesn't necessarily ask for it overtly, but I have a feeling that this is what Judge Chutkan is thinking. I think she's going to try to resolve as many of Donald Trump's motions, and there are like 4 or 5 of these motions to dismiss. I think she's trying to do them in one omnibus order. So when Donald Trump appeals, the order to be appealed will now kind of disentangle or put back together, rather, the various motions that Trump tried to bifurcate and trifurcate and continue to divide. Let's take a look just here what Special Counsel Jack Smith is saying here in this opposition to defendant's motion to stay or pause the deadlines pending the motion to dismiss presidential immunity. After careful consideration of the public interest and the parties' proposals for a trial date in this case, including the defendant Donald Trump's initial attempt to postpone trial for almost 3 years, this court selected March 4th, 2024 to begin trial. At every opportunity since, the defendant Donald Trump has tried to delay and disrupt the court's reasonable schedule working toward that date. His newest delay tactic is to move the court to, quote, stay all proceedings in this case until the issues raised in his presidential immunity dismissal motion, quote, are fully resolved. The defendant's motion cites general case law regarding immunity claims in the appellate context, but provides no legal basis for the relief he seeks, which is effectively for the court to immediately surrender its authority to manage this case. The court should deny the defendant's motion for a stay. In addition, the defendant's stay motion exposes his intention to use his meritless immunity claim to disrupt the court's schedule. Accordingly, to prevent undue delay and maintain the trial date, the court should consider and decide first among the motions pending on the docket the defendant's 2 claims that could be subject to interlocutory appeal: presidential immunity and double jeopardy. And then Special Counsel Jack Smith gets into it and basically says that the defendant planned to file this motion for months, but waited until now in hopes of grinding pretrial matters to a halt closer to the trial date. And by the way, what have we been saying here in the MeidasTouch Network? That was Trump's strategy. Trump's doing that. Special Counsel Jack Smith saying things that we were telling you were the arguments that were going to be made weeks ago. Special Counsel Jack Smith goes on to say, as early as August 28, 2023, for instance, defense counsel informed the court that the defendant would raise executive immunity with the court, likely this week or early next week, which is very complex and sophisticated motion regarding whether or not this court would even have jurisdiction over the case. But the defendant did not file that immunity motion that week or the following. Instead, he waited more than a month before filing the promised pleading on October 5th. The defendant then waited another month to file the stay motion late at night on November 1. Tellingly, earlier that same day, when defense counsel appeared at a hearing in the defendant's criminal case in the Southern District of Florida, he used this court's March 4th trial date and pretrial schedule as an excuse to try to delay that trial without disclosing that within hours he would file his stay motion here, seeking to disrupt and delay the very deadline lines in this case that he was using as a pretense. In short, defendant Donald Trump's actions make clear that his ultimate objective with the stay motion, as he consistently has been doing in this case and other matters, is to delay trial at all costs for as long as possible. Folks, that's Donald Trump's strategy. It isn't to defend, it is to delay. And as I was saying, if he was confident in his case, if he felt strongly about the defenses that he has, well, then go through the process that other criminal defendants do. Introduce evidence, provide data points, show us the facts. But no, it's delay, running like the little petulant fascist coward that he is. That is who he is, a coward and a traitor. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We are on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. We will keep you updated as soon as we get a ruling from Judge Tanya Chutkin, and have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.